today at NCA's Guide.
Like everybody here, I'm assuming everyone on this call is an internationally trained lawyer. So I'm an internationally trained lawyer like you all. I moved from Nigeria to Canada a couple of years ago. I went through the NCA exams, just like you are probably doing so the same right now. I also tutor Canadian administrative law with directions for immigrants in trades and profession in partnership with Bow Valley College. So it's a government-funded program only for Calgary, residents of Calgary. I also currently work at the Calgary offices of Dentons Canada LLP. So you are in great hands today, and I'm hoping that we are going to have a very fruitful and productive discussion. So a few ground rules: try and turn on your videos if you can. Trust me, it's for your own benefit. I love to see your faces, but at the same time, I'm not doing just because I want to see your faces. And also, if you don't want to turn on your video, try as much as possible to be responsive. I have seen that the introductory sessions can be so great that you may not even need any additional sessions. But again, I'm not discounting the need to join my intensive classes anyways. But if you want to get the best out of this class, please pay attention. I'm probably just going to take maybe 2-3 hours of your time and we're going to be out of here. And if you have any questions, let me know. I'm willing to answer any questions. Unfortunately, we will not be able to cover everything in administrative law today. It's quite impossible, but I'm going to do my best to give you like a big picture overview so that you kind of have an idea. So what these introductory sessions do is it helps you know the direction to start your reading or to start your studying, because sometimes when you start studying an NCA course, it starts to feel somehow abstract, and then you start thinking, what are they really talking about? So this introductory session today, our objective today is to ensure that by the time you pick your notes up after the class today, you understand what the syllabus is really talking about. So does anyone want to volunteer to introduce themselves today, or everyone is shy and no one wants to say anything? So if you want to introduce yourself, can you use the raise your hand feature? You see something, it should be at the top right of your window if you're using your PC to join the class today. You see participants, show conversation, then use the raise your hand feature to kind of indicate if you want to introduce yourself. Okay, no takers. No one wants to introduce themselves. Okay, thanks, Hilary. Please, I welcome more hands. So, Hilary, can we have you?
Hi, good morning. Well, my name is Hilary. I'm from Venezuela. So I studied law in Venezuela and I moved to Canada 5 years ago, but I have been working in supply chain. So my goal to become a lawyer in Canada is because I want to be a lawyer in international trade. So yeah, so I want to understand a little bit how is the process and all those things.
Right, thanks. Thanks a lot, Hilary. RG, that's all I can see. So I don't know if it means anything or if that's the full name. So RG.
Hi. Yes. Hi, everyone. Sorry, my video can't turn on at the moment. I am Rashima Gordon Morgan. I'm from Jamaica. I'm a practicing attorney. I've been practicing law for a few years now. However, I plan to migrate to Canada next year. So I'll be taking the exams. So yeah.
Yeah, thanks. Thanks for joining us and thanks for volunteering to introduce yourself.
You're welcome.
Any other person? Wow, we've got 28 people in this class, so 26 people don't want to introduce themselves. Interesting. All right. I'm not going to force people to do that, so it's totally optional. I guess is someone volunteering? Onyechi, do you want to go?
Hi, can you hear me? Sorry, my connection is very poor. I'm on the road. I'm about to get to where I'm going. So my name is Onye, and like everyone else, internationally trained lawyer, and looking to get as much as I can from this class and probably from the intensive courses. Thank you.
All right, thanks, Onye. Great to have you here. So let's dive into what we are here to do today, since no one else wants us to know their name. And by the way, I usually do this in my introductory session, so I'm just going to do it again today. I have a special gift for the most involved participants in this class today. So try as much as possible to participate. It's a it's a mouth-watering gift. So trust me, it's going to be worth your time. So if you're interested in participating, I mean, if I ask questions, you don't have to know the answer, but try. I feel like it helps you to understand more. Okay, so I'm just going to do a little bit of an overview and, definitions, some of the definitions of admin law. Now, I know this may be a bit theoretical, but I think it helps sometimes to get like a perspective to what we want to discuss. As you can see on the screen, you can see different definitions that have been offered. This may not be in your notes, but just bear with me. You'll see Barron's Canadian Law Dictionary defines administrative law as those rules of law that concerns the exercise of the powers and privileges of the executive branch of government. And he also says it's mostly concerned with the actions and decisions pursuant to the powers given to the executive by the parliament and provincial legislatures. Now, again, we also see that admin law is concerned about the rules that exist to control admin tribunals, bodies and commissions, and admin actions in its broader. Now, in doing that, the courts want to make sure that they are exercising those powers within the bounds of the law. Now, that itself is a very complicated statement because the lawmakers are the ones making the law. So if the lawmakers have made the law and those guys are executing, what the lawmakers say they can within the bounds of the laws that the lawmakers made, are they not technically doing it within the bounds of the law? Yes and no. Yes, in the sense that, yes, they are. No, in the sense that the court interprets the laws and the court can decide otherwise, which is where administrative law becomes really complex. But it's really not complex at all. We just need to understand the interactions between these three arms of government. What does the executive do? What does the legislative arm of government, what do they do? What does the judiciary do? How do they interact with each other? That's exactly what we are doing in this course. Now, to further break it down and get more further practical, say you are a legal practitioner in Canada, you're a lawyer in Canada, you are practicing administrative law. Now, when your client has an administrative law issue, they will not come to you and say, what is correctness, what is reasonableness, what's palpable and overriding error. They're not going to do that. All they're going to do is just to say, I have an issue. What can you do for me? It's now up to you to try and interpret what their problem is within the bounds of the law. Now, I'm going to give you guys a very, very relatable example. Has anyone gotten a speeding ticket before? Or you parked somewhere in a wrong spot downtown, wherever you are, Calgary, Toronto, anywhere. Now, you can actually appeal those tickets. It's called an administrative appeal. So say, for example, and I've gotten so many tickets, I can't count them anyway. So say, for example, I got a speeding ticket somewhere around downtown, and then I think I wasn't speeding, or maybe there was an emergency, and I feel like I actually have a good case to appeal. So I decided to go to the courthouse, and I went before the first appearance prosecutor, to tell them, you know what? I don't think I should pay these tickets. Now, it's some sort of admin appeal. Now, in doing that, you are going to have to advise your client on how you want to successfully win that appeal. Now, how do you want to win that appeal? You are going to either attack that issue on procedural grounds or attack it on substantive grounds, which is where the old issue of procedural fairness and substantive review comes into play. We already know that administrative law concerns the exercise of powers and privileges of the executive branch of government and how they exercise this power, who is putting a check on them, who is watching them to be sure that they're exercising these powers within the bounds of the law. Now, we've got David Jones also says admin law deals with legal limitations on the actions of government officials and the remedies which are available to anyone affected by a transgression of these limits. So the admin guys have done something, you don't like it, you want to appeal it. That's exactly what we are doing right here. How do you appeal administrative decisions? That's what we are doing. That's what we are here to learn in this course. Now, there is something called the Statutory Powers and Procedures Act. I just thought I should mention this up front now. So these are more like procedural acts in, provincial, in the provinces. We've got one in Ontario, the Ontario's Statutory Powers and Procedural Act, SPPA. the Our Brothers Admin Procedures and Jurisdiction Act. We have the Quebec's Act representing administrative justice. We've got the BC's Administrative Tribunals Act and other procedural codes. Now, let us go further and break down administrative law in terms that will be easy for people that have studied. I know some people have probably started studying. So what I've been talking about so far is a bit abstract. So it's more like a big picture overview. So if it's sounding really weird, that's not what you expected to write in the exam. I'm just trying to give you an abstract overview of what the course is about. So don't be worried. Don't be dismayed. Now let's go into the ones that you are familiar with in your notes. So in your notes, you've probably seen things like procedural fairness, and you've probably seen things like substantive review before in your notes if you've started studying. Now, administrative law is broadly divided into two. If you look into your notes, you see that the first half of your notes is going to talk about procedural fairness review. The second half of your notes is going to talk about substantive review. What do they mean? What exactly does procedural fairness review mean? What exactly does substantive review mean? I'm going to show you guys a chart shortly so you can follow me as I'm discussing this. So we can broadly say what you'll be discussing in the exam. I like to start thinking about the exam from the introductory session because I believe there's no time to waste. You're writing the exam in, I don't know, less than a month or maybe a month and a few days from now. So I like to start talking about the exam from the introductory classes. So broadly, what you'll be discussing in your exam is going to be, it can be outside of procedural fairness review and substantive review. So what exactly do they mean? Now, if a client approaches you and say, and I think we can all relate to this example, my visa was denied. My study visa was denied, and I want to make sure that can you appeal this decision for me? That's an administrative appeal. Now, if your lawyer is not going to tell you the theoretical part of what they need to do, the lawyer is probably just going to say, do you know what? We are going to either attack that decision on a procedural ground or on a substantive ground. Now, when you claim to be challenging a decision on a procedural ground, you are basically saying you will look to the procedures that the administrative decision maker followed in arriving at their decision. And when you look to those procedures, you want to see if there's any flaw or any defect in that procedure. Once there is a defect in procedure, you can use it to appeal the decision and get the decision overruled. Now, if there's nothing in the procedure that you can hold on to, then you can also look at the substance of the decision, which is where substantive review comes into play. Now, looking at the substance of the decision essentially means that you want to review the actual decision itself to know whether it makes sense. Now, how do you do that? We are going to talk about that subsequently. For everyone that has practiced here, I'm assuming that a good number of us on this call today have either practiced for a few years or maybe, I think an average internationally trained lawyer has practiced for minimum 5 years in their home country before moving, an average. I think just one or two have, maybe I've met maybe 1, 2, 3 or 4 people that, apart from people that were born here that went abroad and came back, I think I've only met maybe 1 or 2, 3 people that studied, became lawyers, and then moved to Canada immediately. It almost doesn't happen. So if you've practiced for a few years before you move to Canada, then you understand that procedures can actually get a matter thrown out in court. Procedures like filing a matter in the wrong jurisdiction, filing a matter out of time. Think of any procedures. So the same thing applies in administrative law. So we're going to look at those procedures, and then we're going to look at how to do a substantive review analysis. Now, in considering procedural fairness analysis, there are several. If you're on two devices, can you mute? I don't know how to pronounce this name. Okiv, would you mute your mic? Hello? Okiv. Can you mute your mic, please? I can hear myself echoing. I'm not even sure he knows. Okay, yeah, I can actually mute you. I didn't know I was that powerful. Okay, all right. So I forgot to ask you guys a question before I started. I'm so sorry about that. Has anyone started studying administrative law? Anybody? Or let me say, has anyone finished studying?
No.
Anybody?
No.
Okay,
Yes.
great.
Started.
Oh, yes. Who's yes?
Yes. Tiwa.
Tiwa, oh, great. Any other person? Okay, so for the ones that have finished studying, I'm very sorry if my analysis sounds too rudimentary. And for the ones that are just starting
okay.
out,
I don't understand
okay.
everything that I've
Okay,
read.
great. All right. So yeah, I'll continue. Now, again, I'll recap. Administrative law is just a means of ensuring that administrative agencies are exercising their powers within the bounds of the law. Now, the powers were delegated by the legislative arm that established those admin agencies, saying, okay, we have established the Immigration, Refugees, and Citizenship Canada to what? To look into granting visa applications to people that are looking to move into Canada. Hence, we've set up an administrative agency. Now, they are going to start exercising that power by determining what I always refer to them as RIP, rights, interests, and privileges, by determining determining the rights, interests, and privileges of individuals in Canada. Now, in doing that, the court wants to make sure that they are doing it the proper way, because the courts feel like they are the only ones that should be interpreting the law. The same way the lawmakers feel like they're the only ones that should be making the law. For people that have done foundations of Canadian law, you see that tussle between the judiciary and the legislative arm of government, debating who is really making the law. There was a very interesting article on that. And the courts feel like if any other person is going to do something similar to what they are doing, then they have to do it the way they are doing it. Now, how does the court determine the rights and interests and privileges of litigants that appear before them? If you want to sue someone to court today, what is the first procedure you have to do? You have to go to the court to file your originating processes, right? When you file the originating processes, you have to ensure, as long as it's a contested application and it's not an ex parte application or something, you have to ensure that you notify the other party by serving the motion on that other party, right? And if you can't find them, you go back to the court to seek what? An order of substituted service. Now, when the other party eventually comes to court, what do? You front load your documents, you do discovery, you disclose relevant, documentation and whatever. When you come to court, each party must be heard by the court. You're allowed to do your examination in chief, cross-examination, and if you have further questions, you do what? You re-examine the witnesses. You present your closing arguments, then the court will rule on what has been presented before it. Also, the court is not expected to descend into the arena. The court is not expected to what? To side any party. The court is expected to be what? An impartial arbiter. Now, all those are what? Procedures. And the court expects the administrative agencies that are deciding the rights and interests of individuals in Canada to follow those procedures. Now, they may not be expecting for people that will eventually attend the intensive classes, when we break this, because we're going to break these procedures down, into we're so sorry. We're going to break everything down one by one. And when we do that, you are going to see that even though the court expects them to follow these procedures, they are not expecting the same level of diligence. So for example, in doing discovery, you don't expect the same level of discovery in criminal law to be done in an administrative setting. So you see the differences. But from the big picture perspective, the court expects them to follow these procedures. Now, when they don't follow those procedures, then we will say there's a procedural issue or there's a procedural fairness defect. So that's exactly what we are considering when we are looking at our procedural fairness analysis. So again, by way of recap, in an administrative law review, we are going to be conducting the review by doing what? A procedural fairness analysis and a substantive review analysis. Now, so let's break down procedural fairness further. In claiming that there was a procedural fairness issue in a decision, you will need to establish certain facts. But before we go there, I want to show you guys some things. I believe everyone can see my screen. So what you see on my screen right now, for everyone that can see my screen, what you see on my screen right now are the potential procedural issues that you may raise on an appeal. So say, for example, you applied to the IRCC and they denied your visa, right? They denied your study visa or whatever. And your lawyer is saying, let us try and attack them on two fronts. Let's attack them on a procedural fairness front and a substantive review front, or let's attack them on both. In attacking them on the procedural front, you want to see whether there are certain procedural defects. The first thing I'm going to ask you if I'm your lawyer is, were you given notice by the IRCC before they made this decision, or when they wanted to decide your matter? If you say no, that's a procedural defect. Now, there's more to it than that, but let's just understand it that way. Now, I don't think discovery really applies in that scenario, but discovery will really apply where you are not allowed to know the fruits of the case to meet. That is, they don't disclose the necessary information you need to know before the hearing itself starts. May not really necessarily be applicable in an immigration case since your documents are already with them anyways. Now, was there any sort of delay? If you tell me there was a delay, then I'll say, oh yeah, that's a potential procedural fairness issue. Were you granted oral hearing before they made their decision? Now, oral hearing is a very complicated thing, and well, all of them are complicated because it's not automatic. It's not the case that everyone is automatically oral hearing. We're going to look at the cases of Khan versus the University of Ottawa and some other cases where the courts, established the procedures or the factors to consider to know when oral hearing is important. Things like when credibility is an issue, as in the case of Khan, and some other cases. Now, open hearing. Hearings are, presumed to always have to be in the open, except the legislation says otherwise or circumstances dictate otherwise. When is a hearing supposed to be closed? We will see instances from the Statutory Powers and Procedures Act in Ontario and, different legislations across the country. Right to counsel is a bit similar to oral hearing too. It's not automatic. There are several factors that we have to consider to know whether someone is going to be entitled to counsel. Factors like whether you're able to present your own answer and defense, factors like whether you understand the case, factors like whether there will be issues of law that will be raised and all that a layman is not expected to understand. So essentially, these are potentially procedural issues that can lead to a procedural fairness review. Now, in your notes, you could probably see it as right to be heard or right to an unbiased decision maker. Some notes would divide it, which is probably the most popular one, into pre-hearing issues, hearing issues, and post-hearing issues. They are saying the same thing. It's just that some happen before the hearing starts, some happen after the hearing has started, and then some happen after the hearing has been concluded. Anyways, so let's go back to the procedural analysis. So again, admin law, procedural fairness review on one hand, substantive review on the other hand. Now, still talking about procedural fairness. If you are claiming that an administrative decision maker was not procedurally fair to you, that's essentially because you are going on appeal. You want to appeal a decision now. Okay, so guys, let me give you guys an example, a real life example that happened to me. So several years ago, I wanted to come to Canada and I wanted to come for LLM and my visa was denied. Now, when I got the transcript of their decision, I saw that the reason they denied the visa was because they said, I have not paid the tuition. But I had paid the tuition and I attached the copy of the receipt to the tuition, copy of the tuition receipt to the application, but they missed it out. Right? Now, they didn't inform me or give me any form of notice that, do you want to regularize your application before we make a decision? They didn't give me any notice. They just made that decision and that was it. So I paid a lot of money and I took them to the Federal High Court. I won the administrative appeal and the visa was issued, even though I ended up not traveling at the end of the day, but the visa was issued. So now, in that kind of instance, how did the lawyers that appealed the case on my behalf, they appealed on procedural grounds, not even the substance of the decision. They didn't even appeal because they felt like the decision itself, because the substance of the decision will be talking about whether the decision that I have not paid the tuition is even a right decision or not, because there was a tuition receipt attached, right? That's the substance of the decision. But the procedure that they used in appealing was that I was not even notified to regularize my application, because if you say someone has not paid, you should at least email them and say, oh, have you paid? If you have paid, could you forward us a copy of the receipt? But they didn't. They just made the decision and dismissed the application. This was several years ago, so maybe they're not doing it anymore. But the point is, if I am claiming that my application was thrown out and I feel like there was a procedural defect in that process, then I have to be entitled to that right first. Right? So which is where we come to the issue of sources of procedural fairness obligations. So for every procedural fairness entitlement that you are going to be claiming on appeal, you have to be entitled to it. You cannot put something on nothing and expect it to stand. Very familiar, hey? So you have to be entitled to every procedural defect or procedural obligations that you are claiming. So if I'm claiming that I ought to have been notified, I ought to have been given right to counsel, I ought to have been heard in person, I ought to have been allowed to conduct a cross-examination of the parties or the parties involved, they should have given me oral discovery, they should have disclosed the relevant documents, for me to, know the fruits of the case against me, blah, 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 blah. The question is, are you entitled to those rights? So how do we know you're entitled to those rights? We have to look into the sources of procedural fairness obligations. So what are these sources? On your screen, you can see here I've got the enabling statute, and I'm going to break them down as far as time is going to permit us. The enabling statute, we've got general procedural statutes, we have the common law, we have the Canadian Charter of Rights and Freedoms, and then we have the Canadian Bill of Rights. Let's put a pin in that. So there's something I also wanted to mention. The very first thing, so for everyone that is just being exposed to administrative law for the first time today, I will urge you to get a copy of the syllabus on the NCA website. So just go to nca.legal and go to schedules and outlines on the tab or something. Download the, I think it was reviewed. Yeah, it was reviewed for September 2021. Download the latest copy of the syllabus. The number one material you should be studying with is the admin law syllabus. And you will see the syllabus starts by stating what the nature of the course is. It regulates the ways in which government operates, blah, 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 that the primary questions concerning the course are, circumstances under which the government decision makers, make decisions are subject to an obligation of procedural fairness to those affected by their decisions, the extent to which the substantive decisions of admin decision makers are subject to merit scrutiny by the courts, blah, 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 and of course, remedies. So those are the most important part of the syllabus. I think you guys should all have a copy of the syllabus. The syllabus also talks about case books and assigned materials. As much as I really urge everyone to read the textbooks, in my opinion, or I can say my professional opinion, and again, I don't want to stop anyone from reading the textbooks. Please do. I've been consulting the textbooks too. I finished my exams in 2019, and I still read administrative law every time. So I'm not saying you shouldn't consult the textbooks. Please do that. But I think you should be good if you have a good note. I'm not going to recommend any notes. You can check our website, nca.legal, for any notes, any study notes on our website. If you find anything there, all well and good. But I'm not going to recommend any notes for you guys. If you have a very good note, and if you attend my classes, you should be good. All right, so, so if you want to read the textbooks, you can. No worries about that. Then another thing I think is really important for you to do is, for each chapter, before you read each chapter, I think you should read what the syllabus says about that chapter first. You will see chapter 1 talks about setting the stage. It talks about, I think we've talked about all this, so I don't need to repeat that. Chapter 2 talks about sources of procedural obligations, which is what we're about to start talking about. So I'm just going to read this extract. We begin with procedural obligations that admin decision makers must observe in exercising their powers. The starting point is understanding where this comes from. As the assigned readings suggest, the answer is from several places. The assigned readings talk about enabling legislation, delegated legislation, guidelines, although for reasons discussed in the material below, be cautious of this, and the common law. We also include a few pages discussing general statutes about procedure, that is the special provincial level statutes imposing procedural rules on the provincial administrative decision makers to which they apply. To this list, you must also include the Charter of Rights and Freedoms. Section 7 is the only one really applicable, and of course the Canadian Bill of Rights. More on those later. So what I'm going to do is, I don't know how far we can cover today, but for everything we're going to discuss, I'll probably just come to the syllabus first so that you guys can see that I'm not misleading you. All right, so let's go back. Now, sources of procedural fairness obligation. You need, sorry, give me a minute, guys. Yeah, sorry about that. So again, just like I mentioned earlier, for every procedural obligation that you are claiming you were not granted by the administrative decision maker for which you are basing your appeal on, you have to be entitled to it, which means you need to consult the various sources of procedural fairness obligation and see which one applies to you and which one grants you that right. So now let's take a deep dive. Now, when we talk about the enabling statutes, what we mean is the statute that establishes the decision maker, the administrative decision maker. So if I'm trying to get the decision of the IRCC against me appealed, it means I have to start by looking at the statute that establishes the Immigration, Refugee, and Citizenship Canada. What is their enabling law? What does their enabling law say about my procedural rights? Because more often than not, enabling laws or enabling statutes are usually going to provide, especially for sophisticated administrative decision makers like IRCC. I know there are some decision makers that you probably even think that the lawmakers didn't think it through before they established them. So they may not have very sophisticated provisions. But for like the IRCC, if you look at I don't know what the name of their law is right now, but if you look at the enabling law, I can guarantee you that you will find very sophisticated provisions with regards to procedural fairness. Some of them will tell you an applicant must be given notice, and within 21 days of receiving an application, which is why if you go to the IRCC's website today, they will tell you if you submit your application for permanent residency, they will tell you the timeline that it must be completed within 6 months, even though the law will still tell them that they can rely on certain issues like COVID-19 and tell you, we're very sorry, we have not been processing applications for the last 1 year. Our law allows us to do that. So even if you decide to take them to court and appeal saying they have been delaying your application, procedural fairness issue, they'll tell you, well, COVID-19. Anyways, so the enabling statute will probably provide for the procedural fairness right that you're looking for. Now, I'm going to take you back to this part of my jottings. Remember, I told you guys these are the potential. If you look at your notes, I don't think you probably have anything outside of this. Maybe you probably have some other things like prejudgment and stuff like that under bias and stuff. But I think these are like the major ones. So now what I usually just do in an exam is when I want to do my sources of procedural fairness, I go into the enabling law. Well, the first thing I do is I look at the scenario. They're going to give you a scenario, something similar to, so this is a scenario on the NCA's website. So they'll tell you, so person is currently in prison in Canada, blah, 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 blah. By the time, we're going to go through this scenario later today when we've gotten a bit of understanding of what we're talking about. So after looking at this scenario, the very first thing I expect a candidate to do in an exam is to start jotting potential procedural fairness issues in the question. As you're reading it, the procedural issues, you should know them so well that they should be jumping at you as you're reading it. So let's do a brief exercise. I don't expect you guys to know it if you have not studied yet. So for example, now we see here in our correspondence with Ernest, the investigator indicated that I will conduct an interview with you before submitting my report, blah, blah, blah. However, the investigator did not contact Ernest. Now, the potential issue that I see here is, number one, an issue of legitimate expectation for someone that has studied. You told me you were going to do something. Legitimate expectation can either be expressed or implied. You told me you're going to do something expressly, but you never did it. Now, am I entitled to that legitimate expectation is another issue entirely. Another potential issue here is an issue of disclosure. if you have interviewed certain people and you're going to use that report against me by submitting it to a committee that's going to make a decision against me, I should be entitled to a copy of that report. Not only that, I should be entitled to cross-examine that report. So going back to potential issues, cross-examination. So when you're looking at a question in the exam, let's start thinking exam mode from now. When you're looking at a question in the exam, as you're studying the paragraph of the fact pattern that they're going to give you, you cannot escape a fact pattern in administrative law. It's for sure. You can't escape it. So as they give you that fact pattern, as you are reading it, you should know the procedural issues so well that as you're saying it, you're just like, I don't know, I always get excited when I read those exam questions, because I'll be like, oh yeah, I know this. This is prejudgment. This is oral hearing issue. This is an issue of cross-examination. This is an issue of this. So after doing that, I jot those issues out. And then the next thing I do is now to go to the enabling statute and see which one the enabling statute provides for. So usually the enabling statute will provide for some. Now, if it doesn't provide for every single procedural fairness issue you are looking for, then you move to the next source of procedural fairness obligation, which is the general procedural statute. Can you guys hear me? I just got a bad quality signal now. You guys can hear me very well. Great. Yeah. So you have looked at the enabling statute and you feel like, oh my God, my client was denied all of these rights during the hearing. But I've checked the enabling statute and I see that the enabling statute only provides for oral hearing and open hearing. And remember, you cannot put something on nothing, which means when you get to the appeal, you have to first of all establish to the courts that my client is entitled to these rights because the statute says so. But if the statute only says the client is entitled to 2 rights, you cannot read in an additional right, right? So you need to look for other sources, right? Now, before I leave the statute and check other sources, there's something I want to mention. You can see something like a brain thought kind of image pop-up thing here. And the syllabus talks about this. And I'm going to quickly talk about it because many candidates fail their exams because of this. Because the enabling statute is so important that if you miss what your enabling statute is, it may affect every other thing you're going to do. And you will see what the syllabus says here. The syllabus says, where is it? Yeah, the assigned readings talk about, let me increase the font or whatever. The assigned readings talk about enabling legislation, delegated legislation, guidelines. Now, although for reasons discussed in the material below, be cautious with this. The syllabus is very important. I have to reiterate it to you guys. Don't study without the syllabus. If anyone is asking for AOC, this is it. The syllabus is your AOC. Be cautious with this. So let's talk about what they mean by that. Now, in your exams, and I'm going to say this for people that will not be joining my intensive classes, I think you should still benefit from this information too anyways. In the exams, they can either give you, so this is the way the NCE exams will be. The NCE exam could either be like this. They'll give you a fact pattern like this, and they will not annex any statute or legislation to it. They won't attach anything. They will probably just give you sections of the law within the, within the fact pattern, provide section 5 or tell you section 42 says this, and that's it. That's one way of setting the question. The second way is they'll give you a fact pattern and they'll now give you like a legislation, like a statute. They will separate it and attach it at the back of the exam. So they can just say the Canadian Human Rights Act, and they'll probably just give you like 5 or 6 sections out of the act. Maybe they'll say section 5, section 9, section 42, section 50, section 62, and that's all you need. That's one way. I'm saying this because I don't want you to get in the exam and you start wondering, oh, where's the enabling statute? I can't find it. Sometimes they will just embed it into the fact pattern and say section 5, section 42. So it's just going to be like this. So don't be surprised if you see that. Now, the other thing I want to mention is, yeah, so still talking about this. Now, when you see questions like that, sometimes the law that is relevant for you will not necessarily be a statute. It may be some sort of delegated legislation. It can also be like a regulation or a guideline. They can use any sort of nomenclature for that. Now, what exactly do you need to watch out for? So let's look at this sample exam question. Let's see what they referenced. Let's see what the enabling law that they referenced in that sample exam question. They referenced Section 45A of the Act. What Act? Let's see. Yeah, the Canadian Human Rights Commission was established under what? The Canadian Human Rights Act. Now, the good thing is that we got an enabling legislation, but some questions. So there was an old sample question. This is probably not on their website anymore. I saved it a long time ago. I think in this old sample question, they referenced the regulation. Yeah. So question 2 of their old sample question, they said, acting under the Federal Public Works Act, the governor in council promulgated a regulation. Now, those kind of questions confuse candidates, and they're like, oh, regulation, guideline, enabling law, which one is it? Because they don't carry the same force of law, and you have to know how they work so you don't mix them up. Now, the very thing you need to watch out for is this. For every decision maker, for every administrative decision maker, they have to have some sort of enabling law. Now, they may not give you the text of the enabling law in the exam, and they may reference a further regulation or a further delegated legislation or a guideline. It's not a problem. But the most important thing you need to really search out for is if they reference any sort of delegated legislation, then the power to make that delegated legislation or regulation or guideline must have been mentioned under the statute. Remember, the administrative decision maker received their power. They got their power to act. From where? Anybody?
The enabling statute.
Who made the enabling statute?
The parliament.
Exactly. So their power to act came from the lawmakers. Now, remember that the lawmakers are the only ones that can make laws. So if the lawmakers now insert it into the enabling law and say, well, you too, you can make some laws if you like about this, and that. If they now decide to make those laws will carry the force of law as if they were made by the parliament. Does that make sense? So which means any law that they make, that the power to make it is not in the initial enabling statute, then it doesn't carry the force of law. Does that make sense?
Please come again.
So the power to act, the power that established the law that established the decision maker, the administrative decision maker, was derived from the lawmakers who established or made the law that established them. So, for example, the IRCC was made, the IRCC Act was promulgated or was made by the Federal Parliament of Canada, right? Now, the Federal Parliament of Canada made the IRCC Act. I don't know if that's the name, disclaimer. The Federal Parliament of Canada made the IRCC Act, and when they made the Act established the IRCC. Which means if the Parliament now inserted into the IRCC Act saying the IRCC can make certain laws or certain regulations, if the IRCC decides to make those regulations, it will be as if it was the Federal Parliament that made the regulations. So it will carry the same force of law. Make sense? It's very important you get this. So I'm happy to repeat it as many times if it doesn't make sense.
Yes, it does.
All right, so which means if they decide to now make a delegated legislation, which has not been delegated, or if they decide to make a regulation that they don't have the power to make based on the enabling law, then that law will not, it will just be a suggestion. So let's look at this sample exam question here. They said this guy promulgated a regulation establishing fair wages policy. Under this regulation, blah, blah, blah. I'm trying to see something. Oh, yeah, so see, this first statement, this first sentence is very important. Acting under the Federal Public Works Act, the governor in council did what? Promulgated a regulation, which means he did it acting under this act, which means he had the power to make it. So the moment a decision maker has a power to make a regulation and they make that regulation, automatically what that means is that regulation, for all intent and purposes, the text of that regulation and the provisions of that regulation becomes the enabling statute for the purpose of our analysis. I hope I'm not confusing you guys. Am I confusing you guys?
No, it's good.
Well, I can't see your faces, so which is why I'm worried that I'm confusing you. All right, so I'll just proceed anyways. As long as I don't get any question from anyone, I'm assuming you're good. All right, so the most important thing you need to just watch out for is if there's some sort of delegated law or legislation or regulation, make sure that there's a direct reference to the enabling statute saying they have the power to make those laws. Otherwise, it's just a suggestion. That's the most important thing you need to watch out for. Now, if all the procedural fairness obligations you're looking for are not in the enabling statutes, move on to the general procedural statutes. Now, the general procedural statutes are they are provincial level procedural laws, but only 4 provinces so far that I know. I don't know if any other province has added one since the last time I checked, but I think only 4 provinces have provincial procedural statutes. And we've got the Ontario SPPA, the Alberta AP, is it APJA now, the one in Quebec, and the one in, is it BC? Is it BC? I think. Yeah, the BC's Administrative Tribunals Act. So now these procedural laws too will provide for certain procedural information that you may need. Now, if they don't have what you need, then you move on to, but remember one thing about provincial procedural statutes is that they only apply to the provinces that made them. So the provincial procedural statute in Ontario will not apply to an administrative decision maker that was established by the provincial law of Alberta. Okay, so I'm going to ask you guys a question now. See who's going to get this question. Yeah, I have to measure involvement anyways. Say there's an administrative decision maker that was established by the provincial parliament of Alberta, for example, and you now have, can you apply the Statutory Powers and Procedures Act in determining procedural fairness obligations to them?
No.
Why?
Because that's Ontario.
Exactly. Exactly. So
can you repeat the question?
So the question is, if your administrative decision maker whose decision you want to take on appeal or to review or take on judicial review is or was established by an act of the parliament or provincial parliament of Alberta, for example, can you apply the Statutory Powers and Procedures Act of Ontario, which is a general procedure? Remember, there are just 4 procedural statutes that we've got so far. One of them is the Statutory Powers and Procedures Act in Ontario. Can you apply it to a decision maker that was established by the Parliament of Alberta?
Not at all.
No, you can't do that.
Why?
Because the provinces will be subject to the enactments by their own provinces.
Exactly. Exactly. So please pay attention to that. So which means you need to always remember at the back of your mind that if my decision maker is a provincial decision maker, I have to, number one, if it's a federal decision maker, don't even bother about procedural statutes.
Exactly.
Because procedural statutes, general procedural statutes they are provincial level laws that cannot even apply to a decision maker that is federal. So the next question is, how do you know whether your decision maker is a federal decision maker or provincial decision maker? No wrong answers. There are no wrong answers. Disclaimer, there are no wrong answers. There are no stupid answers. Just give it a try.
You look at the act.
It doesn't contain, okay.
Whether it's an act or a general procedure statute. Looking at if it's from Ontario or Alberta.
Okay.
And then if it's the parliament, it's going to be an act. But if it's from the provinces, it's going to state that it's from the province.
And the fact of the matter will also let us know what bodies are involved. what decision makers are involved, and that will probably let us know whether it's a provincial or a federal administrator.
Okay, any other takers?
I would say that I think you need to look at the content of the law. That would tell you what body powers are being conferred on, and if you can tie the administrator to probably the federal law or the provincial law, I think that gives you the answer to what you're looking for.
Yeah, I think everyone is right to one extent or the other. The easiest way. So now it depends on the kind of question that they give you. Remember, I told you sometimes they integrate the laws into the fact pattern, right? Sometimes they'll give you a separate statute, a separate law apart from the question. Now, if they integrate it into the fact pattern, it may be a bit difficult. If it's a separate statute, you will see the heading of the statute saying an act of the Federal Parliament of Canada or an act of the Provincial Parliament of British Columbia. So all those ones are a bit easy. But if they integrate it into the question, something similar to this, then you may not really know. Then you may need to employ other means to tell. So things like what the last speaker mentioned, like think about for people that have taken constitutional law, think about section 91 and 92. Things under federal, things under provincial. For example, you already know that something like human rights, Canadian Human Rights Act, this already is a federal issue. You cannot expect that a Canadian Human Rights Commission is a provincial commission. It's a federal commission. Now, the question itself does not state that. Then another thing someone mentioned also is look at the question itself, see some other pointers. You can see that anything that is immigration related is also going to be something that is federal. It's not going to be provincial. Another thing you can see, I don't know, someone also mentioned something that was very important that I can't remember now, but altogether, you need to figure out if they are provincial or federal. Very important, because it's going to determine what is going to be applicable to them, because general procedural statutes are not going to apply to federal decision makers. If you put, and I've seen a lot of failure reports, well, they were not my candidates. Let me give you guys a disclaimer. There were people that, there were people that probably, maybe made one mistake or the other, and maybe they panicked, because I think everyone is good enough to pass these exams. But sometimes when you panic, then you start feeling like, oh, can I do this? Can I do that? There was a particular candidate that I had a chat with after failing the exams, and the person told me, and I was asking the person the questions, and the person knew everything, but they just basically panicked, So what I just want to say, I'm showing you guys, I'm not going to show, I'm trying to make sure that what's it called now? I don't disclose the candidate's number for confidentiality purposes. But when you see comments of the examiner in this failure report, you will see that they are just minor issues that can really make you lose some marks. For example, you see, this is probably before the new syllabus was released anyways, you see things on the issue of this was before the new syllabus. There was something I was trying to point out to you guys. You see something like when the person talked about Baker procedural fairness intensity, that this should have been undertaken. This is a very cheap thing. Baker factors, very, very cheap. They're just 5 factors. But you can see that the examiner picked up on that. So the point is, you have to pay so much attention to those little things, because they can end up becoming the things that will define your final results. So figure it out, whether it's federal or provincial, can be very important. Now, say your decision maker is a federal decision maker, then this doesn't apply. But if it's a provincial decision maker, the next question is, do they have a procedural level statute in that province? Otherwise, the rest don't apply. Now it's time to move to the common law. Now let's look at what the syllabus says with regards to common law. Can somebody read this part of the syllabus for me, or for us rather? Can someone read this for us?
I can.
Okay, please, thanks.
Now that you understand that procedural obligations come from a number of different sources, you need to understand which of these procedural rules applies where. We call this the trigger or threshold. Where is a given procedural obligation triggered? Where procedural rules come from legislation, typically but not always the legislation that gives the decision maker his or her powers in the first place. The answer to the trigger question is in the legislation itself. So too, with the general statutes about procedure, they contain their own triggers. So you need to be careful to read that legislation if it applies to your decision maker. And a word of warning, make sure the statute does apply to your decision maker. Ask, could a provincial general procedural statute ever apply to a federal administrative decision maker? Also, realize that even where there is a statutory provision for a hearing, there may be questions as to who is entitled to participate. This is particularly important where the matters in issue are hearings about big projects, such as oil and gas pipelines. Here too, the terms of the statutory provisions may be critical, and issues can arise out of the sections that give the hearing body discretion as to the participatory rights. We can make more general observations about other sources of procedural obligations. The readings focus in particular on the trigger for common law procedural fairness. Basically, there are two triggers, what we can call the knight and Indian head, three-pronged trigger, and a concept known as legitimate expectation. Where the requirements of these triggers are met, then procedural fairness is owed by the administrative decision maker. What that means in practice is a more complex discussion involving consideration of the content of the procedural fairness. More on that below. For our purposes here, make sure you understand when common law procedural fairness is triggered, and be sure you focus your attention on the modern rules. There is history in these readings, which should help clarify where the modern rule comes from. But history is history, and on the exam, you need to understand the rule that applies now. Pay attention to some of the exceptions and constraints on the triggers as well. So for legitimate expectation, note the court's views on procedural versus substantive promises. For the knight trigger, the readings talk about final versus preliminary decisions and the related issue of investigations and recommendations. Note also exceptions to this exception. We turn to other exceptions to the triggering of procedural fairness in the next section.
Yeah, so thank you so much, Miriam. You can see exceptions to exceptions and exceptions to the exceptions. That's how important you have to pay attention to, some of these things under procedural fairness. If you see, so in terms of the common law as a source of procedural fairness obligation, one thing I should start by mentioning is we usually apply the common law when there is some sort of lacuna or gap in the enabling statutes. The common law cannot be used to change the statutes. Remember I said, say for example, the common law, okay, so now say for example, a client or an applicant was denied the right to counsel expressly by a statute. The statute expressly says you will not have right to counsel before this administrative tribunal. The common law cannot do anything about that. The charter can, maybe, depending on whether it's triggered. You will see that the syllabus says mentions that, I just need to move the syllabus here. The syllabus mentions triggers, thresholds, so which means for every source of procedural fairness obligation here, they must have been triggered. And then the threshold of application or of applicability must have been met before you can say they apply to your given scenario. What exactly does that mean? So let's unpack that. Now, let's go back to the statute that we talked about. Usually the triggers for the statute is usually what? The statute itself. The syllabus mentions that where is it? Where procedural obligations come from legislation, the legislation itself, the answer to the trigger question is in the legislation itself. So what exactly does that mean? It means that the mere fact that the statute establishes that decision maker and also brings the individual that the decision maker is about or has already determined their rights, interests, and privileges within their jurisdiction, it already means it's applicable. Similarly, a very, very good example is the IRCC that we're using all day. The IRCC Act empowers the IRCC, to determine the rights, interests, and privileges of visa applicants, for example. Now, that law brings both the IRCC and anyone that is applying for a visa into Canada within a room, saying that the IRCC has the power to determine their rights and interests. That makes the IRCC Act applicable to that situation, which is why the syllabus will tell you the trigger of the enabling statute or the legislation is in the legislation itself. So you will see things like, if you go back to this sample exam question, Canadian Human Rights Act right here, what makes it applicable to Mr. Ernest? To understand this, I always ask candidates in the exam, in the intensive classes rather, I always ask them this question. If you want to understand what it means for the trigger of the statute to be in the statute. Now, this guy was in prison, and the plot of the issue was, when he was in prison, he said it was deemed inadmissible to Canada, blah, blah, blah. But then he was retained in a Canadian correctional center. Now, he's claiming that his prison has a chaplaincy service for inmates, but they don't have a Buddhist chaplain. And he thinks it's discrimination. Now, he wants to take the Correctional Services Canada to some sort of decision maker to try and review that decision. So he's dragging them to the Canadian Human Rights Commission. Now, the very first question I'm going to ask you is, why did Mr. Ernest, why did he drag the Correctional Services Canada to the Canadian Human Rights Commission? That's how you know the issue of the trigger of the statutes being within the statutes. Why didn't he drag them to the Immigration, Refugee, and Citizenship Canada? Why didn't he drag them to the Law Society of Alberta or Law Society of Upper Canada or Ontario? Why didn't he drag them to the Law Society of BC? Does anyone want to try and answer that question? It sounds like a stupid question, but it's a very important question.
Well, I think because the subject matter here is discrimination, and it's just really appropriate that resolve a complaint that relates to discrimination, we should probably bring it before the Human Rights Commission.
You are on track, but that's not the real reason.
Could it be that the Canadian Human Rights Commission is enacted or authorizing the authorized body under the Canadian Human Rights Act, which would make them the direct commission that he would go to based on what is stated in the Human Rights Act?
Exactly. The Human Rights Act in Section 5 says it is discriminatory practice to deny access to people, blah, blah, blah. And one of the prohibited grounds of discrimination is what? Religion. That provision or section of the Canadian Human Rights Act established that relationship between Ernest and the Human Rights Commission. The moment this section was included in the statutes, that served as a door for Ernest to walk in and subject himself to the Human Rights Commission's jurisdiction. And the moment he passes through that door and the Human Rights Commission decides to decide his rights, interest, and privilege, then it only follows that the Human Rights Act should be applicable to Ernest himself if he wants to review that decision. So which is why, again, when we get to the issue of Knight 3 prongs test, you'll probably understand this better when we look at the relationship between the decision maker and the applicant. You understand that better. But the most important part of that trigger being in the statute is, ask yourself, why is my applicant, because the applicant is the person that wants to review the decision of the decision maker, why is the applicant seeking to review this decision? Start with that. Then, why did the applicant get involved with this decision maker in the first place? Something must have established that relationship. You don't just walk. If I want to become a lawyer in Ontario today, I won't go to the Law Society of BC. I will go to the designated agency for that. And for me to have gone to that designated agency, there must have been a law that states that they are the designated agency. That is the trigger. All right, so General Procedural Statutes, again, always in the statutes to be in the respective procedural statutes. Now, for these three other ones, the common law, the Charter and Bill of Rights, their triggers are very tricky. They are different. They are not so easy to figure out. So their triggers, the trigger for the common law, for example, now is what we call the Knight three-pronged test and the concept of legitimate expectation, just like Miriam read in the syllabus a few minutes ago. So let's try and break them down. I think we're really running out of time. I think I should probably try and summarize this procedural part so we can talk about the substantive part too. Otherwise, we are not going to get there before we run out of time. So the Knight three-pronged test was established. There are three factors that were established in the case of Knight versus Indian Edge. I would advise you guys, if you will not be joining the general intensive classes, to study that case. Don't go into the exam without studying it. I'll list some cases, judicial decisions in administrative law that you cannot afford not to study. Baker versus Canada, Knight versus Indian Edge. Let me see. Of course, Vavilov, the case of Vavilov. Belv, Canada's case. Oh, sorry. Someone say something.
Nicholson?
Did someone say something? Are you?
Yes. I said Nicholson.
Oh, Nicholson. Oh, I didn't know you were suggesting a case. I thought you were asking a question. Yeah, Nicholson's case. Trying to remember them. Let me see. Let me see if I have. I think I've got something here that I can probably. I'm sure I have something here that I can probably show you guys. So you can look at. Yeah, reference with Canada Assistance Plan, Authorson versus Canada. Matnew's case. Matnew's case is very important when we are looking at the issue of discretion public policy. If we have some time, we're going to quickly consider this because it's actually some sort of legislative decision issue, because in administrative law, we are always going to be considering issues that fall on the administrative end of the spectrum and the legislative end of the spectrum. And this case really talks about when an ordinary issue that's not supposed to be on the legislative end of the spectrum can automatically fall on that spectrum. And if the decision is a legislative decision, it is not amenable to procedural fairness. Cardinal versus Director of Kent, Iwin Toy versus Quebec. This is the case that talks about the charter only applying to natural persons. And we're going to talk about that. Shikawi versus Canada. Not really so important, but you should know it. Wilson versus BC Medical expanded the definition of liberty. When we look at charter, the Blanco versus BC also talks about another type of stress, psychological stress, which can trigger security of the persons under Section 7 of the charter. What other cases do we have here? Zelioni's case, Ontario Human Rights Commission's case, Saskatchewan Human Rights versus Cordela's case. In Right to Counsel, we have Parrish, Tarrant, Howard, New Brunswick Minister of Health, cross-examination. I mean, these cases are in your notes, so of Vavilov, definitely. Yeah, National Committee for Justice and Liberty versus National Energy Board. Very important for buyers. It sets out the test for buyers. Reggie's case. Yeah, I think you study Reggie's case, even though most people don't cite them in the exam now, but it's a very important case in admin law nonetheless. Valente versus the Queen. You should study Dunsmuir just to get a bit of the history, but you're not expected to cite Dunsmuir in the exam anymore. So anyways, let's go back to analysis. So common law Knight three-prongs test. In the case of Knight versus Indian Ed, do you guys want to take a break? Are you good?
No, we're fine. Thank you.
You're good. Okay.
Yes.
Because I can talk for the next 4 hours. So just to be sure that everyone is okay. All right. So in the case of Knight versus Indian Ed, what happened in that case was there was this guy. I'm just gonna paraphrase. There was this guy. He was working for some sort of public institution, and he was dismissed. And then he claimed that if his employer is a public body, then it automatically follows that they should afford him procedural fairness before they dismiss him, thinking it becomes an administrative issue. Initially, the court agreed with him, but then in the case of Dunsmuir, the court set aside that decision saying no. If you are working for an employer, it does not matter whether they're a public institution or not. Your employment should be governed by your employment contract, subject to certain exceptions. And the exceptions are judges, for example. And actually, there was a recent NCA exam. I think that was the exam that, I don't know, maybe March this year or something, that there was a judge. The issue was an issue of a judge. And that's an exception to that particular issue of you work for somebody and automatically they have to owe you some sort of procedural fairness obligation. That's an exception to that. Now, there's another exception which talks about where the, and I think this should be in your notes. You know what? Let me just pull it up right now so that we're not talking about, trying to remember. I think they are called the Dunsmuir exceptions. I probably got this spelling wrong. Okay, Acrobat can't find it. Dunsmuir gives me grief every time. Yeah, okay. I think I finally got the spelling right. Trying to find those Dunsmuir exceptions for you guys. Just bear with me, guys. You know what? Let's go to the case of Knight. Knight should have it. Yeah, this is it. Yeah, these are the exceptions to the common law duty of fairness. So remember what the court said in Dunsmuir was, if you're employed by anybody, whether it's government, whether it's private individual, let your contract, let your dismissal or whatever be governed by your employment contract, subject to 3 exceptions. Number 1, if you're a public officer, like a judge, and most of those public officers are probably not going to have a contract of employment. So you should be entitled to procedural fairness. Number 2, where you're a public employee and you're not protected by a contract of employment, that's number 1. Number 2, where an office holder is expressly subject to summary dismissal. And number 3, where a duty of fairness flows by necessary implication from the statutory power governing the employment relationship. Anyways, so I just wanted to point that out. So in the case of Knight, that was exactly what happened. And the court now went ahead to set out 3 factors that will let us know where there is an existence of a duty of fairness. So we refer to it as the general duty of fairness. That is, even if the statute does not provide for any procedural obligation, even if the general procedural statute is not applicable, there may still be an existence of a general duty of fairness on the part of the decision maker. And that is what the case of Knight versus Indian Head tries to kind of set out, for future cases. And we have 3 factors. The first factor is the nature of the decision. That's the very first factor in the Knight versus, I think I should probably have it here in my framework. And by the way, I think for everyone that would be joining my intensive classes, I'm still going to talk about this framework in detail. But if this is the last time I'll be seeing you, I should probably take some time to talk about it. Now, I don't recommend you buying this framework now because it's not a note and it can end up confusing you if you start studying it, if you start studying with it from the beginning of your studies. I usually recommend at least studying halfway first before you get it. So essentially what the framework does is, I was the very first candidate to use the framework. In my exam, I realized in my previous exams, criminal law and the likes, I think administrative law was my 4th exam. I realized that the challenge of most candidates is that they know it, they know what they want to do, They have an idea of the principle, but when they get into the exam mode, they don't know how they want to write it down. And then they start thinking, where do I start from? Sometimes when you now write it, you feel like you didn't start at the right place, and then you want to impute it somewhere. So that's exactly what the framework does. So the framework is there to help you pass the exams. It is more like a surefire way of passing the exam without losing your thoughts. But the framework works on what you have studied. You cannot go as an empty tablet into the exam hall with the framework and expect to pass. So, which is why I usually don't talk about it immediately, but just in case I won't be seeing you again, you will see the framework talks about the beginning part of the, when you want to answer a question on procedural fairness review, what you need to do first, the first step you need to take. You're going to see references telling you to insert facts of your question, insert the enabling law, insert this, insert that. So basically, insert cases, it will tell you where a certain thing apply, where it doesn't apply. The same thing applies for substantive review. You see, where is it? Let me just quickly run through this thing. You see where it's an issue of legislative intent, rule of law. You will know where it will tell you where standard of reasonableness apply. This is where you should use this. Only consider writing this if this is your standard. If your standard is correctness, this is like a blob that you can use. If your standard is palpable and overriding error, this is what you can use. Where charter is triggered, there are different considerations entirely, which I'm going to talk about if we have some time. Things that you can use in that instances. And of course, the issue of the remedies that was recently introduced by the NCA in the June 2021 syllabus. All right, so now let's look at the 9 factors, the nature of the decision. That's the very first factor. So the nature of the decision talks about, so there are 3 factors: nature of the decision, and then we've got the relationship existing between the administrative decision maker and the individual, and of course the effect of the decision. Now, talking about the nature of the decision, there are 2 things that you need to watch out for in the nature of the decision. You need to watch out for, sorry, give me a sec. I'm just trying to open this here. Okay, it's not there. Anyways, so in the nature of the decision factor, you need to watch out for whether the decision is a legislative decision versus an administrative decision, or whether it's a final decision versus a preliminary decision. Does anyone want to give us insights into that? Anyone that has studied? Anybody? Volunteers? Remember, there's no stupid answer. Esther, Tiwa, any one of you?
What's the question again? Sorry.
Okay, so the question is, we are currently considering the night 3-pronged factors. And I said the factors, it's called 3-pronged because there are 3, right? Nature of the decision, the relationship between the decision maker and the applicant, and the effect of the decision. So now, under the nature of the decision factor, the issues you need to address under that factor are: number 1, whether this decision is a legislative decision or an administrative decision. Number 2, whether it's a final decision or a preliminary decision. So can you give us insight into what that means and what the significance of each means?
Okay, for the preliminary, I think the preliminary has to do with investigations or like inquiry before the final decision is made. So the rule says that if it's a preliminary one, it won't work. However, there are exceptions. So if the that preliminary investigation will now be used at the end of the day, then yes, it will. So that's my idea for that.
What about, okay, so go ahead, go on.
So for the legislative decision or admin one, for the legislative one, I think it has to do with immunity of the parliament. Like they give them this kind of sort of respect. So if the decision is coming from, or if it is a legislative one in nature, then it doesn't deserve any procedural fairness obligation. But if it is an admin one, okay, the difference, according to what I understand, is that the admin one is like I know it, but I don't know how to explain it.
Don't worry, just explain any way you understand.
Okay, if the admin one has to do with some sort of like a certain, like if it's targeted to a specific kind of people, like it's not general in nature. I'm not sure what I'm saying, but at least I have
No,
an
go
idea.
ahead. Go ahead. You're on track actually.
Okay. Okay, if it's targeted at a specific number of, like if it's targeted to a small kind of people, then yes, we can say that is an admin decision. But if it is like a general, like general for everybody, then I think it's a legislative one. I'm not sure. Maybe I'm mixing it with each other,
Well,
but I'm not sure.
I'll give you points for trying, and you, like they say, E for effort, right? And you actually have the right idea. You have the right idea. I just think you need to break it down further, which I would do. Honestly, if I decide to break everything down further, we're not going to leave here tonight or this afternoon because there's so many things to break down. You want to talk? You want to say something?
Yeah, for the legislative decision, it means if the decision is from the parliament, the act of the parliament, and then for the admin, it means if it's from admin body, if the decision is made from an admin body. Then when you say final decision, it means the decision of the admin, but that's the final decision, as it's simply stated. Then preliminary decision means not yet final, but maybe it's I can't remember, but I know preliminary is not the final decision it's not the final decision of the tribunal. Maybe it's subject to some other things being done before it becomes final. But it's preliminary. The final is the final decision. That's it.
Okay, thanks for your contribution. Esther, do you want to say something? Or you're still raising your hand from before?
No, I don't want to say anything. It was a mistake. I'm sorry.
Oh, okay. RG, you want to say something?
Well, in terms of the legislative versus what was the other one again? The administrative. It's to me the legislative is on a more broader scope as compared to administrative, which is directly related to maybe a particular set of persons or class of persons, whereas legislative is broad, general.
Okay. All right. Yeah. Thanks for your contribution. Onyechi.
Okay, I just wanted to also add that talking about the legislative nature of the decision, it has to do with when the decision maker is in maybe introducing, like everyone else said, something that is regulatory, that is flowing out of their authorities, or their authority to establish some further rules that, of course, are not, targeted specifically at any subset of people or set of people, but are more general in nature. So where that is being introduced, it goes beyond the administrative setting now. It's more like something that the courts or further bodies or further reviewing bodies will give deference to, because it is inherent in them to be able to do that. So it won't be subject to any procedural fairness tests or whatever. And then talking about what was the other one? The preliminary versus final. I mean, the preliminary means that there's still some other steps open, other options, or other further steps open to the applicant, that have to be exhausted. But where, of course, it could also be, it could be by way of an investigation, inquiry, and all that. But where that decision, that particular avenue is looking like it could be final, it could be looking like it may be preliminary, but in essence, that preliminary could be used to establish a final decision. Then that person would have more procedural fairness options open to them. That's my understanding.
Thanks for your contribution, Onyechi. Miriam, you want to say something? Miriam, was it a mistake?
No, it wasn't.
Okay.
So like I would say that for the distinction between the preliminary and the final decision would be, you know, if a decision is made in the course of, say, the proceedings, I think that would suffice as preliminary, because like they haven't come to a final conclusion. I think it's final if, you know, that conclusion is made at the end of I don't know if the word is proceedings. I haven't studied admin law courses, admin law NC topics yet. And then for the legislative decision, I think that would be like a decision that is probably policy based. I think that probably explains it well. And then the admin decision would be, you know, a decision that an administrative body, you know, makes. Yeah, I just wanted to contribute that. So.
All right, thanks, Miriam. Onyechi, did you raise your hand up again, or was a mistake?
No.
An RG, an AA, are you guys raising up your hands again?
Oh no.
No.
Oh, okay, great. All right, thanks everyone that contributed to the discussion, and I'll say you're all on track, but there may be more to it than that. So I just think maybe we should just break it down. Well, technically you're all right. I just think it may be easier to break it down for people that don't know what it's really about yet. So when we talk about final versus preliminary decision on one hand, and legislative versus administrative decisions on the other hand, there are several things you need to put into consideration. So let's look at the legislative versus administrative decision. And yeah, there's actually an exercise I always do. Let me see if I still have it somewhere here so we can go through it together. So it may actually help you. Good. Yeah, so this is going to help you understand legislative versus administrative law powers easily. So let's look at what happens in a typical administrative law power flow and what happens in a typical legislative power flow. So when we're talking about an administrative law power exercise, essentially the legislature has made a law, like the Parliament of Canada making the IRCC Act, establishing the IRCC to determine the rights and privileges of people that are applying for study visas and permanent residency, right? So if the IRCC decides to do that, to exercise that power, what they really exercised was an admin law power. Make sense? Okay, moving on. So again, a different power flow. The Parliament of Canada makes the IRCC Act, again, disclaimer, I don't know if that's the real name, makes the IRCC Act. The IRCC Act now establishes the IRCC. And now the Act now empowers IRCC to make regulations about people that want to come to Canada during COVID-19, or to make any regulations in times of emergencies. And they decided to now do what? To make regulations with regards to when they were, consider applications because of COVID-19, and they decide to make that regulation or that law. What the IRCC just exercised was a legislative power, not an administrative power. Make sense? Now that's the foundation. I need to be sure it makes sense before we take it a bit, dial it up a bit, So now there are some instances where it's an admin power. It looks like it's an admin power, but it's indeed a legislative power, or reverse. So let's look at what an admin power should really look like. An exercise of admin power should be an ADM applying a law, which is their enabling law. And that application should be of specific, it should be specific. That is, there should be a target audience. It should be applied to an individual, on an organization, or a category of people. Then you know that this is an administrative law power. For example, my study visa application, like I told you guys, I'm a target audience, an individual, right? Then you know that's an exercise of admin power. Now, exercise of a legislative power, again, they are making a law or regulation pursuant to their enabling statutes, but it should not be of specific application. It should be sufficiently general in application and not particular to or focused on a reasonably narrow subset of persons. Which means if a decision maker is claiming that I have just exercised a legislative power, and remember, when a decision maker exercises their legislative power, they don't owe you procedural fairness. In fact, for people that have done foundation, you will see that in the process of making law, the lawmakers don't even owe anyone the duty, even the aboriginals, they don't owe them the duty to consult while making the law. Now, when they are done with the law, they can consult. But while making that law, it's the concept of parliamentary sovereignty or supremacy, whichever one applies. They don't owe it to anybody. They don't even owe it to, I mean, I'm probably going to the realm of criminal law now to make good laws. And they can even make retroactive laws, except maybe it's a criminal issue or something. But let's leave that. That's criminal law. But the point is, it must be sufficiently general in application and not particular to or focused on a narrow subset of persons, which means if we go back to this administrative law flow, law power flow, and what they did was to establish an admin body and determine the rights, interests, and privilege of individual, fine, they exercise their admin power. But what if they decide to make a law further to their enabling statutes, but that law is now of specific application? The problem with that is, even though technically they were exercising their legislative power, it automatically becomes an admin power because it is now affecting someone specifically. So let me give you guys an example. So you guys are in the class right now, and I don't like the face of Taiwo because she's a twin and I'm a twin. I'm just joking. And I don't like, let's just say I don't like her face, and I want to do something that is going to affect her. So I now decide to say, anyone that is wearing a silver braided hair is hereby ejected from this class. That is my law. Now, it was a law. I just made a law, but technically that law was of specific application because she's the only one I can see that has a silver braided hair. So I just made a law relying on the power that was given to me by NCA guys to make any regulation in this class. But the law has affected the rights and interest and privilege of Taiwo. Oh, I don't know if Taiwo is your last name or first name. Is it your last name?
My last name.
It's your last name, you're not a twin. Oh my God. So it has affected the rights of Aderonke. So even though I was making a law, but technically I just exercised an admin power because admin powers really occurs when an administrative decision maker makes a decision that touches on the rights, interests, and privileges of an individual. Does that make sense? So, and the syllabus, and I didn't make this up, the syllabus actually talked about it. Where is it again? What were we talking about just now? It should probably be in legislative decisions and emergencies. Yeah, it's here. So you see, the syllabus says common law procedural fairness rules may also fail to be triggered where there are emergencies and also where a decision is said to be of a legislative nature. Be wary of the latter. It is a very ambiguous concept. In its clearest form, it means no procedural fairness where an admin decision maker is introducing, e.g., a regulation. That's the form of, which is what I just talked about now. But a legislative decision means more than this. Boiled down to its essence, it can be a decision that is sufficiently general and not particular to or focused on a reasonably narrow subset of persons. Exactly what this means, you need to contemplate in looking at the readings. Well, I just told you what the reading says. And you need to appreciate that the general rule that no procedural fairness where a decision is legislative in nature is itself subject to exceptions. So pay attention. Because I think they did that in the previous question. I don't know. Where was it again? Maybe it was this. I don't know. Maybe it was this question. We don't have the time to go through it. And everyone, I remember I was in a study group then when I was preparing for the exam, and everyone was like, no, it's an admin law. It's a legislative power. And I was like, nah, it's not. Because the syllabus already says, even if you're exercising a legislative power and it's specific, thereby affecting the rights, interests, and privileges of someone, it becomes an admin law power automatically. Does everyone understand that? Does anyone need clarification on that? At least if you don't understand anything in this introductory class, you should get that. Okay, so let me quickly wrap up procedural fairness. So the next factor, okay, yeah, so we just talked about legislative and administrative. So if it is legislative in nature, so one thing about Knight three-prongs test that you should understand, there are three factors, and I try to call them, and I'm not sure even if it's the right word to use. I refer to them as cumulative factors in the sense that, but basically what I mean by that is they are, all three factors must point towards the existence of a duty of fairness. If one does not point towards the existence of a duty of fairness, then this will not trigger the application of the common law. Remember, these are just triggers. Knight three-prongs test and legitimate expectation, they are just triggers. So we are basically trying to see whether the common law will be applicable by considering these tests. That is the Knight three-prongs test and legitimate expectation. So if all the three factors under the Knight three-prongs test don't point to an existence of a general duty of fairness, then it doesn't trigger the application of common law. So the first factor, nature of the decision, we're looking at whether it's a legislative versus whether it's administrative. If it is legislative, so part 1A, if it's legislative, no duty of fairness. If it's administrative, then there's a duty of fairness. Part 1B, final or preliminary. You guys have already talked about preliminary and final decisions. Unfortunately, I don't want to go deeper into that. Under that, there is an issue of investigations and recommendations and the likes, but I'm just going to have to skip it because of time. But if it's a preliminary decision, preliminary decisions by their general nature don't attract procedural fairness. Again, there are other exceptions to that. Final decisions, of course, attract procedural fairness. So if you can conclude that the nature of the decision factor points towards the existence of a duty of fairness, you can just mark that in your mind. Check. Then move to the second factor, the relationship between the individual and the admin body. I tried explaining that earlier when I was talking about the issue of contract of employment and the likes. That was under that factor that the court decided that factor. So if the nature of the decision is the one that is such that points towards the existence of a duty of fairness, you check that in your mind. You've got two factors. Now you need one more factor because all three must agree. It's not like the Baker test that you just need some. Now, the third factor talks about the effect of the decision. Now, this is a very subjective factor. The third factor is so subjective, and I always tell people that more often than not, I don't think I've ever seen a question where the third factor does not agree with the rest of the two. Because it's so subjective, it's just about you trying to prove that this decision is important to the applicant. And more often than not, it's going to be important to them. It's either for you to say, oh, if my applicant is not granted this decision, if it's not favorable, the person is going to be deported. If the person is, just look for an excuse in the scenario. I'm sure you'll find something. So if all three factors point towards the existence of a duty of fairness, then you can now say the Knight three-pronged factors have triggered the application of the common law. Now, it doesn't end there because there's another trigger for the common law, which is the concept of legitimate expectation. Now, the question you should probably have at the back of your mind right now is, do I use both triggers or do I use one? Now, you have to analyze both. And it's very possible for both of them to trigger the common law. And it's also very possible for none of them to trigger the common law. So you should be prepared to analyze both, whether or not they are going to both trigger the application of the common law or not. So what is legitimate expectation? Because of time, I'll quickly run through it. It's just basically an expectation that is legitimate. That is, someone says something or someone promised you something, and you are in the right to expect that the person will deliver on it. So what exactly does that mean? So for example, if I promise you guys right now that everyone that is in this class is automatically enrolled for my intensive classes. You know, I'm sure everyone is going to be like, Kenny, you promised us legitimate expectation that we are automatically enrolled in your intensive classes, right? Now, but there are several other factors that we have to consider, because legitimate expectation can either be oral or express. Yeah, no, that's not it. It can either be express or implied. Yeah, sorry. It can either be express or implied. So express in the sense that it was either said to you or written out to you, or implied in the sense that you looked at a series of past practices and you generated you implied from those past practices that this is meant to happen. So I'm going to break it down further. So if you're implying something, this applies a lot in union cases, and things like that. But let's try and think about something that is relatable to everyone, for someone that hasn't studied yet. We already know now we've gotten wind of it that the NCA is going to change their exams back to 3 hours, right? Instead of 4 in 2022. So let's assume they did not give any advisory that they were doing that. You just got your admin law exam in December. Oh, well, they already gave us an advisory that it's going to be 2022. But then you're about to write your exams in December, admin law. But you got to the exam hall and you saw 3 hours. I'm sure you're going to be mad that what's going on? Everyone has been getting 4 hours. Why? Because you have implied from a series of past practice or past practices that everyone has been getting 4 hours. So you were expecting. You had no reason not to have expected it. You were expecting to get that 4 hours too. But there are caveats to legitimate expectation, especially this one that is implied from practice. Number one caveat for this that is implied from past practices is you must know about the practice. If you didn't know that NCA was giving people 4 hours, you cannot come and claim, well, that's difficult to prove, right? There's no way the NCA will know that you didn't know. But theoretically, in the exam, the applicant must know. Someone asked me a very interesting question in the last diet, one of my candidates, and the person was like, oh, how would they prove that the applicant didn't know? And I said, well, this is not the law court. This is not an adversarial fight. In the exam, just look at your scenario. If your scenario says the person didn't know, then that's your answer. They don't know. If your scenario says they knew, then they know or they knew. If your scenario is silent, assume and state your assumptions. And say, I am assuming that this person did not know. And then go ahead and answer the question. So that's just the way to answer that question. Then a general caveat for legitimate expectation is you cannot use legitimate expectation to what's the right way to put it now? You cannot use it to generate a substantive outcome. And that itself is a very, very complicated statement. I'll try as much as possible to simplify it in the little time we've got. Now, what do we mean by you can't use it to generate a substantive outcome is that legitimate expectation itself is a product of the common law. And because of that, anything you are looking for, anything you're looking to get out of your expectation that you think is legitimate has to be procedural in nature. Once it is substantive, now I'm not talking about substantive review, because I think people get it mixed up. I'm not talking about substantive review right now. But once your expectation is a substantive one, then it's not going to stand. The best you're going to get out of it is some kind of enhanced procedural fairness obligation. Now, I didn't make that up. The syllabus says something about that, and I'm just going to try and show you guys right now. Where are you? Yeah, this is it. Specifically, that's chapter 7. Specifically, the Baker test suggests, well, we don't need that. Yeah, with legitimate expectations, the content of the procedural obligation is generally what was promised in the procedural promise that gave rise to the legitimate expectation in the first place. If the promise was substantive, you will not be able to enforce it directly. But at the very least, it may lead to enhanced or more procedural fairness. Now, what this means, you will understand this more when we look at the context of procedural fairness obligation. You understand that more when we get there. If I try to explain it now, it's probably be confusing. So, what does it mean when a promise is substantive and when a promise is procedural? I think we should break that down for you to understand this statement. What does it mean when a promise is substantive and when a promise is procedural? A promise is procedural if what you are looking to get out of it is only going to help the process. And it is substantive when it's somehow attached to the final outcome. So let me give you an example. I think I've given this example several times before. When the NCA promised that they were changing their exams to the duration of the exams from 3 hours to 4 hours, what happened in that instance was they said we're changing from 3 to 4 hours, and essentially what they did. Okay, so I'm going to make it a question. Yeah, I think it's better that way. So when the NCA changed, they promised that they were going to change the exam from 3 to 4 hours. So that promise, what if you got into the exam and you found out that they didn't change the exam from 3 to 4 hours and it was still 3 hours? And I'm gonna call people randomly now. Do you think that promise is a procedural promise? And people have started dropping off. I won't call you a promise. Sorry, I apologize. I apologize for saying I'll call you. I will volunteer. I will allow you to volunteer. Please don't drop off because I said I will ask questions though. Anyways, why people have video and Zoom on Microsoft Teams shy? So if the NCA promised 4 hours instead of 3, and then they changed it, they shifted the goalpost in the middle of the game by retaining 3 hours when you got to your exam center. Do you think the promise they made to increase the duration to 4 hours is a procedural promise or a substantive promise, and why? Support your answer with the aid of statutory and judicial decisions. I'm just kidding, but why?
Well, I'd say, if I'm allowed to speak,
Yeah,
I'd say it's a procedural promise and not a substantive promise.
Okay, why?
I say that because I think adjusting the time, or the time itself within which you're expected to complete your exam, is a procedural issue. Because when I think of procedure, I think of, an official way of doing a particular thing. And I think the official way with regards to timing was adjusted. So I think that would be a procedural promise and not a substantive.
Okay, thanks for your contribution. AA. Do you want to say something, or was it from before? I love these initials, RG.
All right, I would say that it is procedural because the promise was given and there was a legitimate expectation that we would have been given the 3 hours to do it, but it is based on the particular exam. So there's nothing much to put it on more than to say that it's procedural.
Okay. Thanks for the attempt. Any other person?
Yeah, I would say it's a procedural thing because there's a legitimate expectation attached to it. We're expecting that it's going to be the time that was specified for it, and so there's an expectation that that's actually what they are going to do, and so it's a procedural thing.
Okay, great. Thanks a lot. Who else wants to say something? Okay, so it's procedural because the fact that they added 1 extra hour to the exam doesn't mean you have passed the exam, because passing the exam is the final outcome. So if they said, or if they promised that you for everyone that enrolls in the August and September and October and November and December diet of the exams, because they are online, have all automatically passed their NCA. And that's a substantive promise. So if they don't deliver on that promise, you cannot, even if you can't enforce it. But if they promise you 1 extra hour, that's not a big deal at all, because the extra hour is only going to allow you to further prove that you know what you want to write in the exam. The fact you can use that 1 extra hour and waste it. You can even use it and it won't even still be enough. So it's a procedural promise. It's just similar to a courtroom. If a judge says, I'm going to give you 1 extra hour to present your case, it doesn't mean you're going to win. So 1 extra hour to write your exam is just 1 extra hour to present your case to the NCA as to why they should give you the certificate of qualification. All right, so now that we've got out of the way, just know that that's a caveat to legitimate expectation. Then the Charter and Bill of Rights. I'm so sorry we can't go into the triggers for the Charter and the Bill of Rights. There's a lot to talk about under them, and we're just not going to finish up today. But know that the triggers for the Charter is Section 7, life, liberty, and security. There are some interesting conversations on that liberty. When we look at the case of BC versus Wilson versus BC Medical, there's an interesting case discussion on that security when we look at Blanco. And also, you should know that the Charter does not apply to corporate applicants. So if the person that is challenging the decision of an administrative body is not an individual, but a corporation, a company, the Charter will not apply to them. Why? The case of Irwin Toy versus Quebec. You can read that further in your own free time. And Bill of Rights. Bill of Rights is a federal law. And because of that, if your decision maker is a provincial decision maker, similar to this general procedural statute, it will not apply to them. Does that make sense? Okay, so I'm just going to skip that. Then, threshold basically is applying the fact of your scenario, apply it to these triggers, then make sure that with the threshold has been, the threshold for application is met. Then if it is, then it's easy for you to say, well, the sources of procedural fairness obligation that are applicable to my client are these, and that. And because of that, the procedural obligations that were denied my client should have been afforded during the hearing stage. Now, it doesn't end there, because if you say my client is entitled to procedural fairness, well, you have to unpack the actual procedural fairness that they are entitled to. But the syllabus says before you do that, you must start with the Baker factors. You guys saw the failure report I showed you earlier. And the failure report was basically saying that the candidate didn't mention the Baker factors, and the person lost a lot of marks. Now, the Baker factors just basically tells us a little bit about the contents. It tells us about the quantum of the procedural fairness obligations that will be held. That is, whether it's going to be a higher degree or a lower degree of procedural fairness. Now, so these factors are 5. Nature of, I think there's the nature of the decision and the process followed, and several other factors. There are 5 of them. But the most important thing for you to note out of those 5 factors, I'm not going to go into explaining them too. I'm just going to skip to substantive review now. The most important thing you should note in those 5 factors is that they don't work the same way. Some people mix them up with the Knight factors. They are not the same. They're not the same as the Knight factors, and they are also, you don't need all 5 factors to agree, just like Knight factors. All you need is the majority. So in the Baker factors, if you've got 3 that points towards, well, Baker factors can either tell you whether it's higher or lower procedural fairness threshold or obligation that is owed. So if 3 points towards higher, that's all you need. Then you know that the degree of procedural fairness that needs to be afforded to the applicant needs to be high. Now, for the content issues itself, I already showed you guys, these are the potential content issues you will see in your notes. Unfortunately, we cannot go through all of them. There are several things to talk about under notice, discovery, delay, oral hearing, and the likes, and all of them. I know bias is a very huge topic. I also know that institutional issues, very huge topic too. So I urge you guys, please study this on your own. If you're not joining the classes, please study it, don't neglect it. we don't have enough time to go through them, so we'll probably just keep and go to the substantive aspect. Now, in terms of substantive review, I'll just do, before I proceed, does anyone have any question? I mean, don't ask me a question about what I didn't discuss, about what I have discussed. Anybody?
I just had a question. Well, my name is Irada. I just want to ask that if your class, like if anyone comes to your class, would you, like, are you gonna cover these again? And
oh yeah, definitely. Oh, definitely.
Okay,
Definitely.
and then is there gonna be like exercise too? Like,
yeah, so I was hoping to talk about that at the end of the class, but
okay.
I can just go ahead and talk about it now. So for the intensive classes, I know people have different ways of studying. I know some people prefer to study alone. They don't like being in classes and the likes, which is why I try and make it as much, as optional as possible. But if you're the kind of person that you think you'd benefit a lot from a general class, and definitely trust me, there's a lot to discuss anyways. Yeah, the classes, we are going to discuss everything from the beginning. And we have assignments in the classes. I think the assignment is probably going to start from the second class because we don't really have much in the first class to test on. And the classes are supposed to be, usually on the schedule, the classes are supposed to be 4 classes, but we end up doing more than 4 classes sometimes because we have a lot to discuss. And of course, people that are candidates enrolled in the intensive classes are also automatically enrolled for the exam review class. So, but the exam review class is open to anyone that is not even in the general class. You can decide to enroll for the exam review class. It's, separately. But if you're in the general class, general intensive classes, you're automatically enrolled for the exam review classes too. So, but the exam review class is a bit focused on answering exam questions, how to attempt exam questions. We're going to solve past questions. Most of these NCA questions you see on the screen, we usually solve them during the exam review stage because that's after the conclusion of the studies. So for anyone that is thinking about joining the general classes, you don't have to worry about registering for that separately. Then you also get some materials which you've probably seen on my screen, study aid. The ones that you don't get for free, you get discounts, on them and all that. Yeah, so that's all about the intensive classes. So if you want to register after the classes, just go to, it should be ncaguides.com, I think. It should be ncaguides.com. I think so. I think it's .com. Yeah, ncaguides.com. So when you get to ncaguides.com, just go over to our class schedule. Go to the class schedule and if you go to the class schedule, you should find administrative law and then you can click on register. Let me see if I can find it. Just show you guys right now. So just go to the website, click on class schedule right here, and scroll down to Canadian Administrative Law, click on register, and that's it. So you'll be able to register right here. All right, any other question so far on what we've talked about? I hope that answers your question. Was it Irada or what was it?
Yeah, Irada. Yeah, thanks for that. And one last thing that I would like to ask, if somebody wants to get ready for the exam, like from scratch, like from your experience, how long does it take?
Well, I prepared for all my exams in 1 month, and I think it's possible too if anyone is willing to do what it takes. I have actually prepared a candidate in 2 weeks before, but the person was willing to do what it took.
Okay.
Right? So it all depends on because people, when I was writing my exams, I was working full time. I was working full time as a paralegal, and it was busy. It was really busy. I think I've probably shared this story before. I used to ditch my car keys and take the train and the bus because I realized that the commute time, instead of driving, I might as well be in a bus and be studying, right? And then my lunch break, I use my lunch break to study on my way back home, take another 1 hour when I get home to study. And before you know it, I've been able to put in 4 hours of study every day, even though I had a full-time job. So it depends on whether you're willing to do what it takes. But I think for everyone that is willing to study every day, minimum 3 hours, you can be ready in 1 month. With intensive classes, you're even at a better position. But again, you have to be willing to do what it takes. If you are the kind of person that you feel like you'd have, I mean, it's okay to take one day off occasionally, but if you go a whole week off, I'm sorry.
Okay, thank you.
So if your exam is in December and this is October 23, even if you're starting from scratch today and you're willing to put in the work, you would be ready.
Even if you're working full time?
Yeah, I was working full time.
Okay, and
we can chat more about this so that we don't drag the class.
Sure.
You can reach out to me. Can send me an email, kenny@ncaguides.com. You can send me an email, reach out to me, LinkedIn, anywhere, anyone that works for you, and we can pick it up.
Okay, sure. Thank you.
Yeah. All right. Any other questions before we move on to substantive review? All right, I'll assume no further questions. So a little bit of background into substantive review analysis. Remember, all we have been talking about so far is a procedural fairness analysis. And I told you that as a lawyer, you're an administrative lawyer, or you handle administrative appeals. A client has approached you that they want a decision to be reviewed. The client isn't going to tell you what to do. You're not going to be telling the client that we're going to do this, we're going to do that. But it's up to you as a lawyer to ask yourself, how do we want to challenge this decision? Are we going to challenge it on procedural grounds? Or are we going to challenge it on substantive grounds? Now, in challenging on procedural grounds, we've been discussing how to do that. And how to do that is basically to ask yourself, were there errors in procedures that we can latch onto to get this decision, turned our way? Now, in looking at those errors in those decisions, you consider the different procedures, you consider the sources of the procedure, of the obligations itself, whether those sources have been triggered, whether their threshold for application has been met, whether the Baker factors points towards a higher degree or not, and what the actual contents are. Those are procedures. Now, to the substance of the decision itself, this doesn't lend itself to procedures in any way. The substantive review analysis does not care about whether you were given notice or whether they gave you disclosure or whatever. No, anything procedure, forget it with procedural fairness. Now, under the substantive analysis, what we really want to know is the decision itself. Does it make sense? Is it a right decision or a wrong decision? Now, that's putting it in its simplest form. Is the decision itself a right decision or a wrong one? Now, for you to know if a decision is right or wrong, you need something to measure it. I mean, how do we measure right and wrong in our society? Laws. Which is why, there was a time, I read one article and somebody said, there was a time that slavery was legal. It was legal to have somebody that is your slave. But now it's not. There was a time that being and I think it's still applying in other countries, some countries till today. There was a time that a man and a man cannot be together in several countries. But now, in some countries, a man and a man can be together, a woman and a woman can be together. So the point is, what is right and wrong in the modern world is not really about morality. It's really about what the law says about it. Now, people are going to have different moral compasses, that's okay. But as far as the Lord has no problem with it, no one can do anything to you. That's essentially what's happening in substantive review too. Now, when you want to review whether the decision of a decision maker is a right or wrong decision, you need a standard. And that is what takes us to the concept of standard of review. Because the only way you can know if a decision of an administrative decision maker is a correct or incorrect or right or wrong one is to review them by certain sets of standards. Now, this standard of review has evolved. This standard of reviews they've evolved over the decades. Now, one thing that I've noticed about administrative law in my study of the course is the standard of review changes every decade. 10 years before Dunsmuir, maybe in the 90s, I can't remember exactly. There was this case, I think it was Bibo's case, and it was probably, maybe it was even before that time anyways. That was the case that introduced the concept of standard of review, and we had 3 standards historically. We had, remember, these standard of reviews are going to help us measure whether a decision is right or wrong, not the procedures. Now, we had historically, we had 3 standards. We had patent on reasonableness, we had reasonableness simpliciter, and then we had the standard of correctness. Now, as at that time, the standard of reasonableness simpliciter and patent on reasonableness were very similar, and they were being applied almost the same way, while correctness was really just standing on its own. Then in Dunsmuir, the court decided to fuse those 2 standards into one. The court fused the standard of patent on reasonableness and the standard of reasonableness simpliciter together to form one standard of reasonableness as we know it today. So post Dunsmuir, we now had reasonableness and then we had correctness. But then, in choosing this standard of review, you need to look at certain pointers. So those pointers pre-Dunsmuir were referred to as the pragmatic and functional factors. Now, post-Dunsmuir, those pointers to selecting the standards, they were referred to as default assumptions. That is, Dunsmuir will just tell you if it is this, or this, then the standard is correctness. If it is this, or that, then the standard is reasonableness. Those were the default assumptions. Then post-Dunsmuir, some cases revived the old pragmatic and functional factors. The cases like COSA, maybe Newfoundland, Norseas, I can't remember all of them now. And it now created a serious problem for admin law candidates. A candidate like myself, because I wrote my exam under the Dunsmuir dispensation. So it means that we now needed to find a way to harmonize the rules of Dunsmuir and the ones post-Dunsmuir to arrive at a standard of review. It was really tough. It was so uncertain. But good news, December 19, 2019, in the case of Vavilov and other cases, the trilogy of cases, the Supreme Court announced that we are no longer going to be using the pragmatic and functional factors or the default assumption or even the rules of Dunsmuir. And the Supreme Court introduced what we call the presumption of reasonableness. Now, you can start writing from here. The presumption of reasonableness is the new selection standard. That is, this is the new way of determining what your standard of review is going to be. So what does this presumption of reasonableness say? It basically says that for every decision that comes before a court, and they are looking for the standard by which to review that decision, and they want to now select that standard, that they should start with the presumption that the standard is reasonableness. But presumptions are meant to be rebutted. So after they have started with that presumption, like when you guys joined the class today, my presumption is that all of you are great guys and you're going to participate in the class. But I've started rebutting that presumption because some people didn't turn their video on, they have not unmuted their mics, they have not answered any question, and they've not asked any question. So I've rebutted that presumption severally today. So presumptions are meant to be rebutted. So you start with the presumption of reasonableness and then you try and rebut it. So how do you rebut that presumption? You start by asking yourself, so there are 2 categories, 2 main categories. Category number 1, legislative intent. Category number 2, rule of law. So under the legislative intent category, the first rebuttal is to ask yourself, does the statute provide for a standard? Because if the statute provides for a standard, then you are expected to apply that standard. If the statute doesn't provide for a standard, then you move to rebuttal number 2 under category 1, which is, does the statute provide for a right of appeal? Now, this is what we call statutory right of appeal. You know what? Let's put a pin there. I want to ask you guys a question. Can anyone differentiate between judicial review and statutory right of appeal? They actually asked this question in one exam, but it wasn't an NCA exam. I think it was one of these universities exams. I don't think NCA is going to ask it, but I don't put anything past the NCA these days. They're asking OBJ question in foundation, multiple choice. So I don't put anything past them these days. So what's the difference between statutory right of appeal and judicial review? Don't bear it in mind that both involve reviewing a decision of an admin decision maker by taking it to the court. But what's the difference? I was hoping to end this class at 3 p.m., but it's not looking likely. Okay, what's the difference? Onyechi.
Okay, I'll just attempt this. So the statutory right of appeal has to do with where a statute provides for a means of, appealing the decision to either tribunal or court within the statute, while to allow for redress and what have you. While the judicial review has to do with the particular court's inherent jurisdiction to review administrative decisions, something like that. It's constitutional.
Okay, you have the right idea and you're on track. Let's hear from others. RG.
I'm gonna skip this one. Thank you.
You're gonna skip? Okay. AA. AA, if you're saying something, we can't hear you. You are muted. Or maybe the person just raised up, or maybe it was raised from before. I'm just going to lower the hands. All right, so yeah, statutory right of appeal is the right to appeal the decision of a decision maker to the courts. And that right must be contained in a statute. The statute must expressly say that you can review our decision. Remember, when we say statutes, we're talking about the enabling statute of the decision maker. The statute must say that you can review our decision if you don't like it. You can take it to court. But judicial review is the same, but it's the same in the sense that you are still going to review the decision, but the right to go on judicial review is not contained in the statutes. As a matter of fact, that right applies when you don't have the right to appeal in the statutes. And that right is basically based on the rule of law. And that's AG of Quebec versus Crevier. In that case, the court basically said that the authority to conduct judicial review is inherent, it's an inherent powers of the court based on the authority of the rule of law. So even if the enabling statute says they cannot, they still can because of the rule of law. So if you get a question and the enabling statute expressly mentions that this decision cannot be reviewed, just laugh and say, I serve a living God, because judicial review says you can based on the rule of law. Does that make sense? Okay, I'm moving on anyways. Yeah, so back to where we were before. Now, this is saying if the statute doesn't provide for a standard, if it does, apply the standard. If it doesn't, then ask yourself if the statute provides for a right of appeal. So we are talking about statutory right of appeal here. Now, let me just quickly chip in this in case I don't remember to maybe even mention it again. Right of appeal here, they've tried to confuse some candidates in the previous exam before. Right of appeal here doesn't refer to the, because within the structure of some administrative decision makers, some laws will tell you you can appeal to a higher body within the same body, from maybe they will say from commission to tribunal to a chairman. That's not what we're talking about here. This is a right of appeal that is going to the courts. So if the statute provides for right of appeal to like another layer within them, that's not what we're talking about here. It has to be the one going to the courts. Does that make sense? So does it provide for the right of appeal? If yes, you need to ask yourself, is it a question of law? If it's a question of law, it's going to be correctness. If no, is it a question of fact or mixed fact and law? If it's a question of mixed fact and law, then the standard is what? The standard of palpable and overriding error. I wish there were time I wish there was time, I probably would have showed you guys how to distinguish a question of law from a question of fact and a question of mixed fact and law. But I'm sure you should probably, I'm not sure if it's in the notes out there. I'm not sure. But anyways, the most important thing is if it's a question of law, it's correctness. If it's a question of fact or mixed fact and law, then the standard is going to be palpable and overriding error. But if the statute does not provide for a right of appeal, then you keep on, then you go to the second category of rebuttals. You have to ask yourself, is it a constitutional question? If it is, correctness applies. Or is it a question of central importance to the legal system? What exactly does this mean? If it is, correctness applies. Or is it a question of jurisdiction between two or more administrative decision makers? If it is, correctness applies. I'm so tempted not to want to go into these three. No, we won't. All right, so if you're unable to rebut the presumption, then the standard of reasonableness stands. Remember, we started with the presumption that the standard is reasonableness. And then we try to wriggle our way around this maze to find ways of rebutting it. If you're able to rebut it, then you settle on a standard. But if you can't, well, the standard stands. Does that make sense? I know if it is the first time you're saying it, it's a lot to take in, but it will make, I promise you it will make sense when you start studying. All right, now there's one other thing I think I should mention is that there's something called the Doré exception. And again, if you have not studied, just listen. Don't stress yourself because it's probably, I'm probably building on more complex issues. So there's a case called the case of Doré versus Loyola. Now, that case has been pre-existing before Vavilov was decided in 2019. And that case has been, governing administrative decisions that touch on charter values or charter issues. I'm not going to go into the full context of the case itself, but just know that it has been governing charter reviews when it's administrative decisions that, that touch on charter issues. Now, when Vavilov came, Vavilov sort of acknowledged Doré by saying that whenever charter consideration is involved, there are two things you have to consider. And this is paragraph 57 of Vavilov. We don't have time to go and read Vavilov, but you can check out paragraph 57 of Vavilov. Vavilov tells us there are two things to consider where your admin issue or your admin review has a charter issue. What do we mean when we say there's a charter issue? Let's go back to this. Remember when we're talking about sources of procedural fairness, and I said section 7 of the charter is a trigger. So if the charter has been triggered here, you already have a charter issue on your hands. As long as the scenario doesn't change. Because some questions we say, assuming the charter was not triggered. And please follow the instruction. There was a sample exam question on the NCA's website where they said, do not deal with charter matters. So follow the instructions. Read it, it's part of the exam. Anyways, going back to what we're talking about. So if the charter has been triggered under procedural fairness, it means there's a charter consideration in your question. And if there's a charter consideration in your question, you cannot choose your standard with this presumption or rebuttals alone. You have to consider what we call the Doré wrinkle. Why do we call it a wrinkle? It's a wrinkle because the case pre-existed before Vavilov, but somehow it has found a way to continue to exist in light of Vavilov. So Vavilov now kind of acknowledges Doré by saying, where there is a charter issue in your question, you need to consider two things. Number one, was it the decision of the ADM that affected the charter rights of the applicants? Number two, was it the interpretation of the enabling statutes that affected the charter rights? They are two separate considerations. And Vavilov is saying, if it is the decision or the discretionary decision that affected the charter rights, then Doré should continue to apply and the standard of reasonableness should govern such review. But Vavilov is also saying that if it's the interpretation of the enabling statute that affected the charter rights, then our own correctness based on Vavilov should apply. That is, this correctness here. So technically, it will now then be considered a constitutional question. Remember, the charter is part of the constitution. But Dore takes the charter out of the constitution if it's the decision of the ADM that affects the charter rights, so which is why we call it a wrinkle. It's a wrinkle on Vavilov. I know this sounds very complicated and maybe convoluted for some if you have not studied. And I can only say that it gets better when you start studying, but it's just good for me to mention it now. Ordinarily, I don't go too far in my introductory sessions. I just try to touch it, just touch it on the surface, because sometimes you may end up scaring somebody and they'll be like, you know what? I am not writing administrative law in December. I'll wait till next year. And I don't want to scare people. Please, admin law is simple. It is simpler than this. I can assure you. I'm not trying to force people to come to the intensive classes, but I can assure you that we are going to break this down if you do decide to join. So it's not complex. And if you do decide to say you don't want to write it in December because you are scared, well, I don't think I could have done more, but it's not complex. That's all I can say. It's very simple. It's sounding complex because I'm pouring a lot of information at once. But I think anyone that has studied will probably just be like, okay, yeah, that checks out. That checks out. I've seen that. Yeah, so that's probably what you'll be feeling like right now. So I think I'm going to stop our discussion there, because the other things that we can talk about now is to now look at those standards in detail. That is to look at what reasonableness means, look at what correctness means, and look at what palpable and overriding error means. But I think it's probably a great idea to stop our discussion there. Any questions?
I do have a question, and that's with regards to your last statement about admin law not being tedious. I've heard in the past that it's the course that has the most content. So my question is like, if you have a course that has so much content, like is it possible to narrow it down? How do you take in all of that information? How do you know what to focus on the most? Or do you just read everything and digest everything, and literally every line, every word, every concept, every principle is a priority for the purpose of the exam? Yeah.
Well, you've already started doing one of the most important things, which is to join classes like this. I always tell people, join as many free sessions as you can. It kind of help you put things into perspective. You don't even have to join a paid session immediately. Join a free session just to kind of understand what you're doing. Then, okay, do I even want to write this exam now? It's kind of helpful in that regard. The other thing you can do when you are definitely sure that you're ready to write the exam is when you join group discussions. So if you have people that are and that may be a bit difficult if you're not in Canada, or you're new to Canada and you don't have friends, which is where joining a class also helps, because I've realized that I think I'm on so many WhatsApp groups, because for each classes that I've had, they all end up forming a WhatsApp group and they never close it, right? So it also helps because when you're in a class with people like that, you automatically have a group that you can bounce things off. And again, when you come to a tutored session, when someone is delivering the classes, it's also easy, because if you've studied, then you see where the person is focusing on, and you can further validate what you've studied. Then also when you join those group discussions with some other people, it's easier, because although group discussions, I must warn you, you have to pick your members of your group very well, because some people will tell you something that is wrong and they'll tell you authoritatively. He'll tell you, no, I am sure it is right. So you have to be very careful of the group too. So don't just join any group, but if you can find people of like minds that you can trust, that they know what they are saying, it's a great idea. So that way, I find it easy to assimilate information when I talk about them than when I actually study. So when we talk, we just talk and talk and talk. And I remember, studying doesn't help me as much as I talk, or listen rather. So that may definitely help. One thing I can tell you in admin law is, it looks like there's a lot of information, but most of them are from cases. Most of the information in your notes are actually from cases. The content itself is not a lot, which is why If you're in a class, I can tell you what that case says in five lines, and I'll still encourage you to go and study, but it becomes easier. For example, there was one case like that, I can't remember. I think it's about 4 pages in, I won't mention the author, but there's a certain author's notes. It's about 4 pages, and I'm like, the author practically copied the entire text of the case in the notes, and that can scare you because you won't even know it's still related to the case. You'll probably think this is what I have to study. So I think it's easier if by now, honestly, I'm just going to be sincere with you. If by now you have finished studying administrative law, at least, I always study once, but I know some people need to do like second and third reading. But if you have not finished doing like a first reading right now, you probably need to do those things. You probably need to join a class. You probably need to find a group. You probably need to find somebody to bounce what you're studying, off of. So it's not the case that because you need to study and then talk to someone. Study and then talk to someone about it. Validate what you have studied, then go back. Study again, talk to someone, because you realize that even in your studies, you've missed a salient point that you didn't pay attention to. And that could be the defining point in the exam. I remember there was one group, I was on one study group with a couple of people when I was writing my exams. And I think it was for foundation. And somebody was talking, and foundations, there will be articles and all that, for people that have done it. And someone was talking about the article. In fact, the person mentioned the title of the article. I was like, is that in the syllabus? But I have not heard of that article before. And guess what? I didn't end up studying the article. I didn't read it at all. But what the person said in that discussion group stuck. And it came out, and I wrote based on it. And of course, I passed the exams. So I don't think it's fair to try to do it alone. It's not impossible. I know people that have done it. It's not impossible to do these studies and exam and everything alone. It's totally possible. Let nobody deceive you. It's possible. But I think it's a lot of work. It's a lot more work, especially if you have a full-time job, to try and do it alone. I don't know if that answers your question.
Yes, it does. Thank you, Kenny.
All right. Any other question?
Hi, Ken.
Hi, RG. I don't know what's the full meaning of the RG. I'm so sorry. Oh, person isn't talking anymore.
Can I hear me?
He said RG.
Yeah, we can. Oh, we can hear you. Was that RG?
No, Olaiton speaking.
Okay, it's Olaiton. Sorry, I thought that was RG. Oh, okay.
Yeah, I just wanted to ask, do you have an advice which exam to take before the other? Like, would it help to take foundation and constitutional law before admin?
People say these things, and I think maybe I'm just an outlier, and I just like to do things in a different way. But people say these things, and I've heard people say start with PR. Warm into the exams. Even PR, people fail PR. People say start with PR. People say put foundation. Do foundation last. Don't do admin yet. Constitutional law. Some will say start with. I remember somebody said start with foundation because that's the foundation. People say all sorts, but the truth is, I can tell you categorically that it's good to do constitutional law because there are some things in constitutional law, you may not even need to necessarily write them in the exams, but there are just some residual knowledge or information that will be helpful. But I don't think it will be so detrimental that you will fail any other course if you don't do it first. For foundation, there's a whole chapter in foundation. The last chapter of foundation is administrative law. So which means if you have done administrative law, you can as well skip that chapter. The only element of foundation in administrative law is the aboriginal. There is an aboriginal topic in admin law, but it's very summarized and they have never tested on it. But you can still study it during admin law. So I don't really think you need to start with a specific one. I was in a group where people said start with PR and constitutional law, and guess what I said? I'm going to show you guys, and I started with criminal law, and I passed. And I passed criminal. I started with criminal law, and I think maybe criminal and foundation or something. And I passed. So really, you can start with anyone. That's what I'm trying to say. You don't have to necessarily start with a specific course. But the thing is, if And again, it's even very difficult now because then we could write any exam during the quarter. But now the exams are monthly. So that is also going to affect your decision making. So for example, I think it's too late to do any other exam this year apart from admin. Right?
Yeah. Yes.
So yeah, it's too late to do any exam. So if you're not doing admin, you are probably not doing it until March next year. So I think that's also something you need to consider. But in terms of whether one is easy or whether one will affect one if you don't do it, I don't really subscribe to that. People say it, I hear it a lot, but I don't subscribe to it really. I think you should be good with anyone. You can decide to start with PR, you can decide to start with criminal law, you'll be fine. Just study and you'll pass.
Sounds good. Thank you.
Any other questions?
Yes. In terms of the notes, so originally I purchased the notes for crim law because I said I was going to do crim first, but then coming to this class, I'm reconsidering, but because admin,
Sorry, what did you say? You're reconsidering what?
maybe doing admin in December because it just from just being in this class, admin seems kind of straightforward.
Okay.
Yeah, it's
So you're saying you want to do it in December?
Yeah.
Oh, okay. I thought I scared you. Oh, I thought I scared you.
No. Because I started crim.
That's good news.
So I'm actually considering doing the admin now. However, for me, I prefer to write my own notes, even though I purchased the notes, which is time consuming with 2 jobs. But do you think that having purchased the notes, because I purchased them from NCA Guide, that it makes sense to just read through them and maybe read the cases in depth?
It depends. It depends. So what's your plan? Do you want to self-study or do you want to join the classes? It depends. It depends on your answer. Well, you don't have to answer it if you don't want to. So I'm just going to answer based on both. So I don't want to put you on the spot. If you are self-studying, then you have to read all those cases because you are probably going to miss something. I'm afraid you may miss something, and I don't want to just say you should skip some cases. Because one thing I found about admin is that some principles are embedded in some. In fact, do you know if you can study all the cases in administrative law, all their past questions always come from cases. So once you study the fact and you know it, when the exam comes out, you will say you feel like it's familiar.
Yeah.
So whenever candidates tell me about their exams and they're like, "Oh, this is what happened," I'm like, "Oh, do you know that's the case of this and this merged together?"
Okay. Yeah.
So, but if you are planning to be in the intensive class, maybe not, because we are most likely going to discuss most of those cases, which may reduce the need for you to study everything. So, which is why I said it depends.
Okay, understood. Thank you.
All right. Well, you're welcome. Any other question? And I'm very sorry we couldn't go in depth. It's just not possible. It's probably just not possible to do that. So, yeah, it's a lot of work talking for hours. All right. If you guys don't have any question, then I think I've done a great job here today, and I didn't leave anyone with doubts, and I didn't scare anyone off till next year. So let me do a bit of a poll. Who is planning to write, just show by raise of hands, who is planning to write admin in December after this class? Oh, a decent number. Okay. Somebody just changed their mind right now. Okay. That's 7 people. Wow.
I don't know. Okay, my hand is up. My device was messing up. So yeah, I'm one of them.
Okay, 9 people. Okay, decent. I guess some people are still worried that they are not ready. But anyways, it's okay. Oh yeah, so we need to pick our most involved person in class today. We don't have a poll function. We don't have a poll function here. Do we? We don't. I think I have a couple of nominees. I would have preferred that people vote, but I have a couple of nominees. I would say you guys can drop your hands. I would say I'm not heard some people's voices today at all, so I think I've heard a lot. Onyechi, RG, AA, who else? Miriam, yeah, Miriam. I've seen Aderonke a lot, but I haven't heard her a lot, but I've seen her a lot. So I'll put her on that list. E for effort. Okay. All right. Yeah, I don't know. Is anyone I'm missing? Did I miss anyone? I don't think so. Please, if I miss you, let me know now. All right. So, I mean, you guys just, the 5 of you, can you please just send me an email at kenny@ncaguides.com. Just say I, then I'll respond to you. All right. Thanks a lot, guys, for joining today. I really appreciate you taking the time. I know it's the weekend and everyone, even though it's raining in Calgary today, so I don't know where you guys are, so maybe it's not raining, so and you feel like you could have gone out to enjoy a bit of sun. So it's a great day to be indoors today in Calgary. But nevertheless, thanks for joining. And yeah, I hope to see as many of you in the intensive classes. And for the ones that I will not be seeing, I wish you all the best in your exams in December or whenever you decide to sit for them. Tiwa, do you have a question or were you raising your hand from before?
I answered in your class. You didn't mention my name.
I didn't mention your name. Okay, you used to send me an email. I probably forgot. Miriam,
You didn't mention my name too.
I mentioned your name. I did. I actually did. I didn't forget your name.
This is Dia.
What?
I just wanted to say that I don't think that anyone said thank you to you for this. This is like 2-3 hours of your time. It's nice to say thank you on behalf of everyone. I'm sure everyone
Thank you.
grateful for your time.
Oh yeah, I was gonna say that as well.
And it's very helpful.
Thank you.
So thank you.
Thank you.
Kenny.
We appreciate your time. And you have actually
Thank you, Mr. Kenny.
to decide to do the exam.
All right, thanks, guys. Enjoy the rest of your weekend.
You too.
Okay.
Bye. Thank you, Kenny.
Thank you.
We are NCA's guides.
Every year, a significant number of foreign-trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the NCAs and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The NCA exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the NCA. This is where we come in.
I have written and passed the Canadian Administrative Law exams.
I have taken and passed the Canadian Professional Responsibility examinations.
I have written and passed the Canadian Criminal Law examinations.
I have written and passed the Canadian Constitutional Law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the NCA examinations present, and we help candidates overcome these difficulties and obstacles in understanding the course materials and the exam formats.
We do this through intensive classes, revisions, spot tests, and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a great track record and excellent results from our past and present candidates. If you're writing the NCA exams and you want to pass them all at your first attempt, join our classes today.